Bet it is.
You can sit wherever you want. We just put your nameplate there. So, and there's a clicker right there in front of you. Okay, you can move over here or down there.
I would stay there because you're gonna.
I'll go grab him. I thought he was back there eating.
He was.
Okay. So maybe it's just using the restroom.
Refer the opening to you and then you refer to Ms. Richter, or just go directly to Ms. Richter?
I think it's Laura's name, isn't it?
Go to Laura.
Or to Laura.
You can go to Carrie.
No,
I'm
please.
just gonna say her name.
You know, I love when you do the Vanna White thing, when you go, ears. Ready when you are.
We're ready when you are.
No, Billis.
Oh, Bill's.
Okay, I'm going to call to order the February 12th, 2019 meeting, work session of the City Commission. Would you call the roll, please?
Commissioner Rocky Smith.
Here.
Commissioner Rachel Lyle Smith.
Here.
Mayor Holliday is absent this evening. President Frank O'Donnell.
Here. First item, do we have any future agenda items that need to be introduced by anyone? Hearing none, we'll move on to the discussion items. 3A, which is PC 19-016, titled as the Legal Land Use Training presented by the Assistant City Attorney, Carrie Richter. Ms. Turway, would you care to make the kickoff?
Thank you very much. I'd just like to introduce you to our favorite Assistant City Attorney, Carrie Richter. She's the only one.
And the favorite.
There you go.
Thank you. My apologies for my delinquency. So I'm thinking that we are going to spend about 45 minutes going through about 10 slides. I know that 2 of the 3 of you have reviewed quasi-judicial land use proceedings before. So I'm going to try to move through that. And I know that Commissioner Lyle Smith works for the agency that is charged with all the rules. So I probably don't need to tell her that there are 18 statewide planning goals. And, you know, we could just have a quiz. You could list them.
There's 19, actually.
Let's not have a quiz.
But yeah.
So anyway, my point is I'm going to try to move through this quickly, give you the high points. I urge you to interrupt me and ask questions. We don't want to talk about any matters that are currently pending, but I can't think of any right now. So anyway, so keep that in mind as we move through. I put these slides on in printout on your dais so you can see them in either form. So we've got land use review categories is sort of the starting place. All local governments have their categories of types of decisions that we make in the land use realm. And they are rated based on the amount of discretion that is involved in making the decision. So type 1 decisions are decisions where there's no discretion, decisions like building permits and there are subdivisions where we know what the setbacks are and we know what the building heights are and we know where the roads are going to be. All of those things are sort of set forth in the standards and they are what we call clear and objective. They're quantifiable standards. So in those cases, there's no analysis that needs to be made. So there's no notice, there's no hearing. These decisions happen over the counter, basically, for Laura and her staff. The type 2 through type 4 decisions are quasi-judicial decisions, and this is sort of the bread and butter of what land use review is all about. This is the conditional use permits, this is the variances, this is the master plans, this is site plan review. These are all these types of decisions fall into these quasi-judicial decisions. And these decisions, you are sitting as a judge. And that's what distinguishes these quasi-judicial decisions from legislative decisions. You are to be reviewing the application to determine if the applicable standards are met, as opposed to making policy and deciding what the standard should be. So because you are evaluating a proposed application for compliance, there is a higher standard on the decision maker to be unbiased, to be forthwith about what the materials are that are in the record that are subject to the review. There's just a higher threshold of ethics that come along with when you are being a judge, as opposed to being more of a politician in the legislative decision type of review. So quasi-judicial decisions, there are 3 types. Type 2 is limited discretion decision-making. These are subdivisions and site plan reviews, and these will only come to you on appeal. If they aren't appealed, then the planning director makes a decision, and that's the final decision. Type 3 decisions, those are the ones that are heard by the Planning Commission and the Historic Review Board, and those, again, get appealed to you. If they don't get appealed, you don't see them. Type 4 decisions are plan amendments, zoning map amendments, and they do come to you because they are a planning commission recommendation with the final decision by the city commission. And again, the reason why we have this more rigorous review for these type 4 decisions, they're more akin to policy. They have a bigger effect. They are more discretion in terms of compatibility or compliance with the comprehensive plan. And because you are asked to interpret those bigger policy questions, that's why type 4 reviews go to you. And then legislative decisions are sort of the other side of the sort of things you review as in the land use arena, and these are long-range policy-making decisions. This is where you're writing code, adopting concept plans, those sorts of things are legislative decisions. And in those cases, you are supposed to be out in the community talking to people about what they think and what the policy ought to be. And so it's a completely different type of role that you play in the legislative arena. So with that background, we're going to talk primarily about the quasi-judicial decisions, because that's where the additional standards, the different procedures are set out in state law, and so we don't have any choice, and that's what our code implements. So at the beginning of every quasi-judicial hearing, the city attorney gets the lucky task of reading the script, and that script sets out the procedures provided in state law about how hearings have to run. And in sum, that script sets out the framework of everything that's going to happen at the public hearing. It says that the applicable criteria have been posted in the notice so that the public's aware of what the approval standards are going to be that the city commission is going to be reviewing. It tells people that there's been a staff report, and again, the staff report is what evaluates, the staff's effort to evaluate the application against the criteria to give the city commission a basis to either approve, deny, or approve with conditions, modify the decision. In the disclosures, we say that testimony is to be directed to the criteria. One of the things that's really important is that our decisions are focused on the evidence presented and the criteria that are before us. A particular applicant could be the very best applicant, could be the nicest people, could do a whole bunch of charitable works, but if the application doesn't meet the criteria, we can't approve it. So we try to focus everyone on the criteria that are before the city commission for review. We say that failure to raise an issue precludes raising it before the Land Use Board of Appeals. One of the things that is built into the land use system is this idea of funneling, of taking all of the issues and sort of narrowing them to identify what are the issues that are in controversy. So staff does this in the staff report. You know, they find the issues that may be in controversy and they highlight them for the city commission or the planning commission in the staff report. Planning commission does that review too, and they sort of narrow issues further, and people come testify and raise their concerns. And so again, we're sort of narrowing the issues, and this continues when it's reviewed before the city commission. We identify what are the close calls, and then ask you to sort of weigh in on those close calls. Not that your review is limited or that the public's participation is limited, but it's a narrowing because we want to identify all the issues. And one of the rules, in order to appeal a decision beyond the city council commission to the Land Use Board of Appeals, is that you have raised all issues. So the public, everyone has an obligation to vet the issues so the city has an opportunity to respond to them. So,
I have a question.
yeah.
Do they need to raise the issue prior to coming to us at like a planning commission meeting, or can the issue be considered raised by the time it reaches us?
It depends on the type of review.
Okay.
Type 2 decisions, the kind that come from the planning director, go directly to you. Those are what we call de novo. De novo means like new. So in those cases, all new issues can be raised.
So that's the criticality of even opening or closing the record too, is it not?
In type 3 decisions, you're limited on appeal to the issues that you raised. And that's, again, that narrowing. We're trying to vet the issues and narrow the scope. You know, we don't want to have, at the 11th hour, a new issue raised that wasn't raised before the planning commission, when the planning commission is charged, the experts charged with sort of having the most knowledge. So that's why we have it structured that way.
So when it gets to city commission, do not look for us to reopen the record. That should not be a practice.
Okay, so there's a record. The record is the written materials and the new evidence that is submitted. That is to be distinguished from a public hearing. Public hearing is where we take testimony, but we limit that testimony to evidence already in the record. So we will have a public hearing. You will open the public hearing at an appealed land use proceeding, but we may or may not take evidence. So people can testify, but we may not take new facts as part of that testimony. Do you see the distinction?
I do, and you or one of your counterparts will be the screening mechanism to decide if that can come forward.
Correct.
Okay.
Correct. And we make that very clear in the notice, whether, at the very start, at the planning commission, whether or not this is a type of proceeding where appeals will be de novo or on the record. So folks at the outset know. And then when we do the disclosure script at the planning commission, we tell people. So they know they have, the planning commission is their only opportunity to bring new evidence. We also say that there's an obligation to raise constitutional issues as part of a local proceeding if you fail to raise constitutional issues, and that is particularly relevant to takings issues, when a local government exacts too much, requires too much in its conditions. If a applicant is not happy with the scope of the conditions, they have an obligation to raise their concerns as part of a local proceeding before they can take us to certain court for a constitutional challenge under the takings clause. And then last but not least, and probably most importantly for your purposes, is this right to an impartial tribunal. Decisions have to be based on testimony and evidence that is part of the record. That means everybody has an opportunity to come in to to the, city recorder or to the planning office and review the materials that you are going to base your decision on. So if you read a newspaper article or a blog post about an appeal that is pending before you and it doesn't make it into the record and it influences your decision, that undermines the propriety of the decision. So it's really important that it's really important that whatever you read outside the hearing room or whatever information you glean about a matter pending before the city outside of the public proceedings, that you share it. And so we have a portion of at the beginning of every quasi-judicial hearing where I will ask the commissioners if they've had any ex parte contacts. And ex parte contacts means contacts, information gleaned outside the hearing, and that can come from somebody running into the grocery store and telling you that they love this project or hate this project, or it can come from the internet, it can come from the newspaper, it can come from anywhere. But if it's outside the hearing, we need to disclose it at the hearing and give folks an opportunity to question you about that information. That is really critical. And one of the things I've seen happen is that we disclose, people running into the grocery store and telling you they love or hate this project is a really obvious one. But I think what happens is we think through these things, and oftentimes it's a policy call, right? It could go either way. And people say, well, I used to be this, or I have walked this river and I think this, or I have particular experience with the traffic because I drive that intersection all the time. Or I know from my experience doing business that this particular use is going to generate more traffic than the applicant thinks it will. All of those things are part of something that are not part of the record. And so you can't divorce yourself from your own experience. You all live in this community, you drive the streets, you use the water, you know what the water pressure is like, you know all those sorts of things. But that kind of stuff needs to come out before the record closes. Before the testimony portion closes. So the way we run the hearings is the applicant usually speaks, and then the public gets to speak. And then after the public speaks, if you're thinking, I have driven Warner Milne, and the traffic is so much more horrible than anybody's talking about. Or I know, what the water situation is. Or I know how this circulation isn't going to work. I know this road is too narrow. I urge you to make those comments before the rebuttal starts. Not, I'm in favor of this. I think the criteria are satisfied. Not evaluating the standards, but the facts. These are facts. If you have some experience that makes you qualified about a circumstance with regard to the application, say it before the record closes. Because if during the deliberation, which is after the record closes, and you all are talking amongst yourselves and you're evaluating the criteria and the facts that are presented, if you present a new fact, the public hasn't had an opportunity to respond. And that's what we're trying to avoid with ex parte disclosures.
So my question is on social media. If you were to read or have read to you a commentary about a specific issue on social media, would that be something you should disclose?
Yes.
And you have to be specific as to, there's an article by John Doe and it says this.
Yes, better yet would be to print it.
And bring it in. Okay.
Or send it to planning staff and they will print it and bring it in.
Okay.
Newspaper articles, bring them in. Because if we can just put them in the record, then everybody knows what people are saying. And everyone has an opportunity to respond.
Understood.
The other thing you need to know about ex parte context, though, is that someone has to bring a challenge in order for this to be an issue. And so I don't want you to be on pins and needles about this, you know, if someone brings a challenge, then we will deal with it by responding to the questions and the concerns raised. This is not a, you know, life or death situation. This is just something we want to maintain the propriety of the process. And so the most we can do that, the better. Decisions also have to be free of actual bias. Actual bias means that a person has a predisposition to make it impossible to render an unbiased decision. And the sort of seminal case on this is Walmart cases where people, you know, are usually not on the fence about Walmart, you know, and certainly 10 years ago, people were not on the fence about Walmart. And people ran whole council races on their position about Walmart. And so these liquid natural gas is another example of these kind of bias cases where councilors run on a platform of stopping these uses. And then they get on the city council and they vote on those proposals. And so the question comes up whether they are predisposed to such a degree that they prejudice the program, prejudice the review. And just so you know, that the bar LUBA has set and the Court of Appeals has set for that is extraordinarily high. So it is not as though if you ran on an anti-Walmart or for pro-Walmart campaign, you could not review that decision if you felt like you could review the application and make a decision based on the criteria. Because again, courts understand that city councilors are citizens, and of course they're going to have opinions, and of course they're going to be passionate, because that's why they came on the city council, city commission in the first place. So that's something that if an application comes up and you feel like, you know, you are close to this, your spouse wants to testify, your child wants to testify, it's important to you, let's have a conversation, you know, you and Tony and I have a conversation about it so we can talk it through. And this is why we have, you know, 5 commissioners, so that there are people who can sit out and things will go on. You also can't have any actual conflict of interest, which is a pecuniary benefit, that the application is likely to have a direct pecuniary benefit or detriment to a decision maker or a family member of a decision maker. Again, if this comes up, I think we had on the Oregon City golf course, I can't remember, one of the planning commissioners had a son who mowed the lawn at the golf course. And so he sat out because his son had a pecuniary interest in the golf course. So anyway, so we can talk about that when applications come up, but those are the sort of impartial tribunal factors that sort of you should need to keep in mind. Public meetings and records requirements. Here we've got public meetings. You all are familiar with majority or a quorum deliberating to a decision is what constitutes a public meeting. And I've talked to some of you before about how meeting substitutes by like a serial meeting, emails with a quorum to talk about city business can be a public meeting, so you want to be careful with that. I know that Laura sometimes distributes materials electronically, and I urge you to ask Laura questions, but don't hit reply all with your questions. Hit reply 1, so we don't have a serial meeting situation. Public meetings are open to the public, and we've got notice of these meetings and minutes. Public records. Almost any writing, including electronic records, made, received, filed, or recorded in connection with city business can be a public record. And this includes work done on private email accounts, if it's city business, on personally purchased computers and handheld devices, if it's city business, could be a public record. And because of that, and because instant messaging and chat rooms that are separate from the city may not be retained, subject to the public records rules, we urge you to use your city designated account for city business. If you get a email on your personal account for city, related to city business, I urge you to forward it to your city account and then respond to it. Because again, we're just trying to collect everything on the city's designated account.
Does the mere presence of what would constitute a quorum of this group at an event where we're not going to discuss business with, that's just a social event. We don't have any issues with that. If I wanted to have a dinner party and invite people, that would be fine.
As long as you don't discuss city business, that's
Which is
the.
really difficult to do.
Come on, you have so many interesting things to talk
Yeah, I
about.
know.
I would make
We
sure,
do.
I would make sure to invite those people who usually represented Counterpoint as hall monitors.
Oh, I thought you were gonna say you were gonna invite really interesting people who would come up with topics that would keep you off the city business topic.
Well, we could put shock collars on everybody. If it went the wrong way, press the button.
When is this party?
I haven't checked the guest list yet, so we just stand down. Please proceed.
So, one of the questions that Commissioner O'Donnell raised had to do with attorney-client privilege. And attorney-client privilege is an exception to the public records doctrine. And so I want to just sort of hit some highlights. This is sort of off the land use path, but it's relevant because I think we ought to cover it, and it's one of the issues that we've been meaning to cover anyway. So, attorney-client privilege exists as an exception to the public records law when the legal advice given is specific to the client, which in this case is Oregon City. So Oregon City is the client, and it is the client, and we represent it through its representatives. Oregon City is a commission manager system, which means the commission sets the direction and policy for the city, but the city manager makes the day-to-day decisions directing the city attorney to take actions in furtherance of that policy. So the way I understand the system to go is that Tony gives us the sort of day-to-day direction pursuant to your sort of policy instruction. So in order to determine if some materials are subject to privilege, we look at whether or not the material is a confidential communication, and so it has to be confidential. So that means that if I provide some legal advice to the city, to Tony, and Tony sends it to you, and you accidentally send it to someone else, the privilege is lost, even if it was unintentional. And so that's why we have to be very careful with privileged materials in, providing privileged handouts and then collecting them afterwards, because we can't let them if they get in the recycling bin and somebody picks them up, the privilege is lost. I can't call it back for accident. So we have to keep confidential communications confidential. The privilege exception only applies to legal advice and not to facts. So if I tell you whether Oregon City won or lost a LUBA case, that is a fact, and that is not privileged. If I tell you how much our office billed in a month on a particular case. That is a fact. That is not privileged. But if I were to share with you our billing sheets that describe the work we would do, that is privileged because that is legal advice. So there's a difference between fact and advice. And I get, Bill and I've had lots of discussions about the gray area there, but that's what the rule says.
If an individual commissioner were to ask legal advice from you, is that protected under attorney-client privilege?
It would depend on the request. If the request was for city business, it would probably be subject to privilege. The only issue with that is that under the manager commission system, the commissioner is to go to the city manager, and then the city manager is to come to the city attorney. But if the question is, you know, what is your, you know, how does a recent decision affect the city, right? If that question is asked to me from Tony, it's privileged. If it's asked to me by the commission as a whole, it's privileged. If it's asked to me by one of you, it's privileged. If one of you comes up to me and asks me what to do about your traffic ticket, not privileged. It's city business.
It's an interesting conversation because once again, it's surfaced in today's social media. The gentleman in the community queried, you know, that the hiring of the attorney by the city manager versus the commission itself and what the impact of that is on a position taken by the attorneys. And I think it's a subject worth addressing. It's kind of a fine line. You know, we direct Tony communicates to you, the communication comes back to us. I'm not overly troubled by it, but it's a good read if you want to take a moment and read it. And I don't know if you've seen it, Tony, or not. It's as of today.
I know that that's a long conversation that we had, 2008, 2009, and we ended up, you know, keeping it the way it was.
So everybody's comfortable with it?
Yeah, but I mean, that conversation has been an ongoing conversation over the years that people have asked, why are we doing, you know, why isn't it structured a different way? And at the time, we felt comfortable, you know, where it was after what that process was after we had that discussion. But I know it's been a question that we've asked back and forth on different occasions or different years, but
Sounds like it's been asked and answered in the past, so.
yeah, although, well, yeah, I think so, but
I mean, I would suppose that if someone is questioning our city attorney's advice to us or their ability to give us non-bias or legal facts or, you know, non-biased opinion where maybe hypothetically Carrie knows that what she's going to tell us, Tony's not happy with, you know, like how
Exactly.
you know, do we have faith in, or in the integrity of our city attorneys to give us information that maybe Tony wouldn't be happy with? So I mean, that scenario is the one, but I assume if we suspect or someone suspects that's happening, I don't know how it's hard for me to imagine that situation, but I mean, there's other avenues. They would have to take that to probably the bar, the state.
Well, I think that, again, the city attorney represents the city through its representatives. So if there was a dispute between the city attorney and the city manager about the type of legal analysis, I think it would take, the resolution would be a discussion between the city attorney, the city manager, and the city commission. I mean, that is how that would play out. Because I don't represent the city manager. I represent the city. And I think that my ethical obligation is to the city through its representatives.
Right.
And our view, you know, the city attorney view is that is both city commission and city manager. But again, the day-to-day policy, the day-to-day actions directions come from the city manager.
Yeah.
So to be absolutely clear, who makes the decision which law firm to hire? Is that by the commission or by you?
By me.
it's the city manager.
Okay. And I think I think you described the issue exactly. And it's the same issue about reports from staff. Do they take a position? Do they make a recommendation? Are they purely objective? And that's always a challenge. I mean, we rely on staff because of expertise. We may or may not agree with the recommended course of action. Okay, thanks.
All right, back to land use. I'm going backward. No, okay, so public hearing procedures, we talked about this a little bit. We have the staff report, they go first, then the applicant's presentation, then the testimony of the public. We hear from both proponents and opponents. The applicant rebuttal and then the deliberation. City Commission usually imposes time limits. They're set forth in the procedures, but nobody has to the deal with time limits is that we need to be uniform. So if we're gonna institute time limits, we need to do it across the board. If we're not gonna do it, we don't have to do it, and we don't have to do it uniformly for every proceeding. If we have a heavy agenda and we've got a full room, time limits, and they can be less than 3 minutes if that's what the commission decides. It's important to keep in mind that in addition to public testimony given orally at a city commission meeting, people have an opportunity to submit things in writing too. And all of that stuff gets reviewed by you. So it is true that we sometimes impose short time limits, but folks do have another forum in which to present their case. So just something to keep in mind is that when we think about this and what the time limits ought to be. And then after we've heard all the testimony, we close the public record, right? And whether that public record included new evidence or it didn't, we close the public record, which means that's the end of the opportunity for folks to submit anything in writing. And we deliberate and we make a decision. And the elements of a sound decision, the things that are challenged when we end up defending decisions at LUBA are sort of threefold. One, interpreting the applicable criteria. Your job is to interpret the standards and determine what they mean. And ambiguous standards are to be interpreted consistent with the purpose and policy of the provision. So we're looking at the context of whatever the policy, whatever the ambiguous provision is around, it contains. We focus on the plain meaning of the terms and try to give them their dictionary definition. And this is sort of like one of those things I always find that when we go to LUBA, there's always sort of one of these interpreting the applicable standards, challenges. And it's one of those things that it's not until you get to LUBA that you really are honed in enough that you really get it, right? And you think, where was I when we were drafting this code? Where was I? Because you just don't think of all of the scenarios that can come up. And so that's why this falls to you. And that's why we try to do our very best to provide you the information you need to interpret the code properly. The second sort of component of sound, legally defensible decision is adequate findings. And that's an explanation of how the facts satisfy the criteria. And the important part is that those findings are not just conclusions. The standard is that the traffic will be adequate. The finding can't be the traffic will be adequate. The finding has to be, here is what the traffic will be. The standard is that the traffic is X. The traffic will be adequate because it will be X. And so my hope is that you'll lean on staff to assist you in drafting defensible findings. But sometimes when we've had a hearing and we've taken new testimony, that's why we have to continue the matter to come back with findings because we haven't written them yet, because issues come up during the hearing.
I have always struggled with that very example you gave, and it has to do with the traffic findings. And, I've been in court many years as a testimony, and firsthand observations are usually allowed.